Hey, Frog Prince Rana here, and thank you for dropping by. Quick prelude. Couple of days ago, I had published a video titled Brexit because we are better than everyone. It was my satirical take on the mistake we call Brexit. It wasn't a video pointing out all the lies, but more showing some of the people and why they had voted to leave. Well, I have been called out on that. Now, in all fairness, it was one of the most thought out and well-written comment I have ever received in my channel. For all my debunking videos, I'm traditionally used to comments like, "You're wrong." Yes, often with the wrong spelling of "you are." So it did take me a while to compose myself, and it was an unfamiliar territory for me. One of the things apparently I was flippant about was the word sovereignty. I believe I said something along the lines of, "Don't ask me what it is." The issue with that word is, it covers a whole range of things. As it was pointed out to me, sovereignty covers many issues from taxation, trade, citizens' right, travel, immigration, criminal justice, and more. Basically the right of state to govern itself. One of the examples I was given on how staying with EU was dismantling our sovereignty. Let me read out that example first. Usman Khan, the Islamic terrorist that killed 2 people on London Bridge and injured 3 others. He was released from prison due to EU human rights legislation. The UK authorities knew he was a risk to public safety, but had to release him from prison for terror offences, even though the parole board deemed him to be a serious risk. This BBC article partly explains it, but with the usual BBC pro-Riemann bias manages to lie by omission, followed by a link to BBC and link to EU Court of Human Rights document. Where were the human rights of the 5 people attacked by convicted terrorist Khan? So in this video, I would like to first touch on what happened with Usman Khan and then have a quick gander at the EU Court of Human Rights. On February 29, November 2019, a terrorist attack took place on London Bridge in which 2 people were killed. The attacker, subsequently identified as Usman Khan, was also shot dead at the scene by the Metropolitan Police. In the aftermath of the attack, it emerged that Khan had previous conviction for offensing relating to terrorism. This had led to debate over how people in the UK are sentenced for terror offences, and in particular over how the previous sentencing of Khan himself was handled. Khan, along with 8 others, were arrested in December 2010. Some in the group were implicated in a plan to blow up the London Stock Exchange, but a case against Khan relating to that plot was never pursued. In January 2012, Khan pleaded guilty to engaging in conduct in preparation for acts of terrorism. He and 3 others admitted to planning to build a madrasa in Kashmir, making it available to men who wished to fight and providing firearms training. They said they did not intend to participate in an act of terrorism in the UK in the immediate future, although they admitted some of the men trained in Kashmir might wish to return to the UK. In February, he was then sentenced to detention of public protection, known as DPP. DPPs were introduced in 2005 following the Criminal Justice Act of 2003 under the Labour government. They are a type of a sentence known as an intermediate sentence. Under these sentences, a prisoner in England and Wales can be held indefinitely until the parole board is satisfied that they can be safely managed in the community. Under this type of sentence, he received a minimum prison term of 8 years. Any time he spent on remand since 2010 was counted toward this sentence. He, along with the 8 others, would then have had to make sure the police were kept regularly informed of where they are staying and whether or not they left the country after release for a period of 30 years from sentencing. On November 30th, 2019, in an article with Daily Mail, Boris Johnson claimed that Khan was arrested 11 years ago under 2008 legislation. This is incorrect, as he was sentenced over 7 years ago under laws first passed in 2003 and which came into force in 2005. There were criticisms of the system, including that it led to overcrowding in prisons, putting pressure on the prison system and the parole board, and that the provisions were too broad, meaning less serious offenders were caught up in it as well as more serious ones. The European Court of Human Rights also found that IPPs were a violation of the right to liberty and security. Following this and other legal actions, IPPS and DPPS were effectively abolished by the coalition government in 2012. The abolition did not take retrospective effect, so offenders who had been previously sentenced under the old laws, including Khan, continued to serve the old type of sentence they were given. Khan, along with all the others found guilty, appealed against his sentence in April 2013. He and several others appealed primarily because when they were originally sentenced, the judge decided that they were more of a risk to the public than those in the group who had planned to blow up the London Stock Exchange. Those were 4 men from London and Cardiff, all British nationals, had been inspired by the preaching of the radical extremist Anwar al-Awlaki and were arrested in December 2010. On this basis, the appeal judge decided that, rather than imposing an indeterminate sentence, those not involved in the stock exchange plan should be sentenced on the same grounds as the others and receive determinate sentence. In other words, that they could not be held indefinitely. Following this appeal, Khan received an extended sentence of 21 years with a custodial terms of 16 years and an extended license of 5 years, the maximum that could be given. Extended sentences typically include a custodial sentence, time spent in prison, and a period on license in the community. The different types of extended sentences available have changed a lot over the years. Khan received the version that would have been available to the judge at the time of his conviction in 2012, rather than the one available during his appeal in 2013. That was an extended sentence for public protection. Khan was then released on license in December 2018. That was at the halfway point of his sentence, including time spent on remand, before his conviction in 2012. Under an EPP, if you were sentenced after 14 July 2008, you can be released automatically after serving half your sentence in custody. The rest is then added to the time spent on license. EPP sentences were themselves abolished for people convicted on or after 3rd of December 2012. One of the main points in the process of Khan's sentencing and release that is being debated is whether or not the parole board played a role or should have played a role in his release. The parole board themselves released a statement saying, "The parole board can confirm it had no involvement with the release of the individual identified as the attacker, who appears to have been released automatically on license as required by law without even being referred to the board." It has been claimed by Home Secretary Priti Patel that the parole board played no role due to the fact the Labour Party changed the law in 2008. It is correct that the requirement to have the parole board sign off on the release of prisoners serving an extended sentence once they reached the halfway point was abolished in 2008 when Labour were in government. She, however, made a false claim on another tweet suggesting that all dangerous terrorists had to be automatically released after half of their jail term. This change only related to extended sentences rather than the indeterminate sentence which Khan previously received. Both the original judge and the appeal judges had the opinion of giving Khan a sentence that would not have seen him automatically released at the halfway point, as indeed the original judge did. In summarizing Khan's previous statement on appeal, the judge did say, "Furthermore, given that it is difficult to identify the extent to which those who have been radicalized, perhaps as a result of immaturity or otherwise, will have modified their views having served a substantial term of imprisonment, and there is an argument for concluding that anyone convicted of such an offense should be incentivized to demonstrate that he can safely be released. Such a decision is then better left to the parole board for consideration, proximate in time to the date when release becomes possible." But it has been argued by some, such as the Secret Barrister blog, that the judge was weighing up the competing arguments for different sentences before settling on an EPP. To further clarify on the current status of the law, on the Andrew Marr show, Shami Chakraborty, Shadow UK Attorney General, claimed that life sentences are still available for those convicted of terror offences. That's correct. It is possible to receive a life sentence for some convictions relating to terrorism. The type of sentences Khan received have since been abolished. The government introduced extended determinate sentences in December 2012. Under this type of sentence, an offender can only be released once 2/3 of the sentence has been served. They can also be given a certain period of time on license afterwards, up to 8 years depending on the type of offense. If the sentence was far less than 10 years in prison and began before 13th of April 2015, then this release can be automatic. If it was for more than 10 years or the offender was sentenced after that date, then it is the decision of the parole board whether you are released or not. Someone in that situation would only be automatically released at the end of their custodial sentence. The Law Commission, the independent body charged with making sure that the law is as fair, modern, simple and as cost-effective as possible, has reported that the current law of sentencing is inefficient and lacks transparency. The law is incredibly complex and difficult to understand, even for experienced judges and lawyers. They say that this undermines public confidence in sentencing and costs a great deal of public money to rectify an appeal. So a statement like he was released from prison due to EU human rights legislation is completely untrue. And dare I say ignorant? I stand correct. But really, where does the EU human rights legislation come in? Well, I couldn't find anything with that relating to Usman Khan. His case was dealt within our jurisdiction. I, however, did find Harun Aswad, an aide to the extremist preacher Abu Hamza, who had his extradition from Britain to the US for alleged terrorism offense blocked by the European Court of Human Rights. Removing Aswad, a UK-based terror suspect whose nationality is unknown, to an American supermax, high-security prison would constitute inhumane or degrading treatment, the Strasbourg court ruled. The decision barring his extradition from Bradmore Psychiatric Hospital, where he is being held, to the US was made on account of his severe mental illness. Aswad, who has paranoid schizophrenia, has been indicated in the US as a co-conspirator in a plan to establish a jihad training camp in Oregon along with Hamza. He was arrested in 2005 in Britain following an extradition request from US authorities. Although in other extradition cases, the ECHR had not found the conditions in ADX Florence facility in Colorado were unacceptable, it deemed that Aswad's case was different because of his mental health condition. In his judgment, the court said it had given full considerations to the submission of the US Department of Justice and observed, in particular, that it could not be determined with certainty in which detention facility or facilities Mr. Aswad would be placed if extradited to the USA, either before or after trial. It was also unclear how long he might expect to remain on remand pending trial. As for his detentions following a possible conviction, although Mr. Aswad would have access to mental health services, regardless of which prison he was detained in, his extradition to a country where he had no ties and where he would face an uncertain future in an yet undetermined institution and possibly be subjected to the highly restrictive regime in ADX Florence would violate Article 3 of the Convention. Article 3 of the European Convention of Human Rights prohibits inhuman or degrading treatment. Last year, the ECHR allowed the extradition of Babar Ahmed and 4 other suspects to US federal supermax prisons, where inmates can spend 22 or 23 hours a day in solitary confinement. After years of wrangling, Hamza was also finally extradited to the US to face terrorism charges. Now, regarding European Convention on Human Rights or ECHR, the convention originally came into force several years after the end of World War II in 1953 to provide for human rights and political freedom within Europe. The jurisdiction of the ECHR covers 47 nations belonging to the Council of Europe, hence it is not limited solely to the 27 countries of the EU. The convention encompasses a wide range of rights including the right to life, freedom from torture, freedom from slavery, the right to liberty, the right to a fair trial, the right not to be punished for something that wasn't against the law at the time, the right to respect for family and private life, freedom of thought, conscience, and religion, freedom of expression, freedom of assembly, the right to marry and start a family, the right not to be discriminated against in respect of these rights, the right to protection of property, the right to education, the right to participate in free elections, and the abolition of the death penalty. The Convention is applied and enforced by the European Court of Human Rights. Over the past decades, the ECHR has been used in many cases involving migrants to the UK to secure leave on the basis of their rights to family and private life and their rights to be free from torture and prosecution in their home country. ECHR was used widely during the Brexit debate. This was at the core of why many people felt the UK should leave the EU. But did leaving the EU means we ended our obligation under ECHR? Now, even though the UK has left the European Union, it is still a participant in the ECHR. The commitment was established before the current trade and cooperation agreement was finalized at the end of 2020. In 2019, the political declaration agreed between the EU and the UK, which outlined the shape of the future relationship between the two sides, stated under core values and rights, the future relationship should incorporate the United Kingdom's continued commitment to respect the framework of ECHR, while the Union and its member state will remain bound by the Charter of Fundamental Rights of the European Union, which reaffirms the rights as the result in particular from the ECHR. The PD also stated, the parties agreed that the scale and scope of future agreements should achieve an appropriate balance between rights and obligations. It should also be underpinned by long-standing commitments to the fundamental rights of individuals, including continued adherence and given effect to the ECHR. As such, this stance set the scene for the EU-UK trade agreement and cemented the UK's commitment to the ECHR. This is confirmed in the Brexit trade agreement, which states under Title II, Basic for Cooperation, Article Comparative 4, Democracy, Rule of Law and Human Rights. 1. The parties shall continue to uphold the shared values and principles of democracy, the rule of law, and respect for human rights, which underpin their domestic and international policies. In that regard, the parties reaffirm their respect for the Universal Declaration of Human Rights and the International Human Rights Treaty to which they are parties. This is already getting to a long, boring video, so I will just finish with my opinion. Those who have been viewers of my other videos would know that I have a strong stance against genocide. I have videos on Tiananmen Square, Uyghurs genocide. There are topics I just didn't get to make any videos yet, would be the Syrian genocide and the ongoing conflict between Israel and Palestine. As for ECHR, I agree with every single of the stances. So if sovereignty means we can do whatever we please within our border, that is a very stupid and arrogant stance to take. Thus, it is either ignorance or the "I don't give a crap as it doesn't affect me" stance. Maybe I should have had that as a group on my Brexit video. On the comment, there are other points to address. But to be honest, I don't want this to be a political channel. I like the black and white of science, and politics are always murky. Some may point out one reasonable reason for Brexit, but there are hundreds of reasons against it. But well, people have spoken, right? Well, that's all for this video. If you have enjoyed it, please do like, comment and share. It does help with the algorithm. If you want to be super awesome, please consider subscribing to keep up with my new contents. If you didn't, maybe let me know why, and I will try my best to address any issues you may have. Thank you so much for watching. Wherever you are, have a safe day. Signing off.
Try.